Hello, everyone. I'm Sarah, and I'm a victim. I want to welcome you back to my channel because today I want to talk about an issue that is deeply personal to me and countless of other families. The devastation caused by repeat DUI offenders. Yes, repeat. As someone who has lost a child to a repeat DUI offender, I've seen firsthand how the system allows these dangerous individuals to continue endangering lives despite laws, like the Watson advertisement in California and the implied consent law, which is throughout the United States. Now, the enforcement fails to stop those who've learned to really manipulate the system. And you know what? I'm going to put in there, I don't know in my case, the mother knows how to manipulate the system too. Because you see, repeat means they've been in and out so many times that they know what to do. Now, every day, repeat DUI offenders are given second chances, third chances, fourth chances. And navigating the legal system that too often prioritizes loopholes over accountability. Just like what happened in my case. Now, there are some ways that we do try to warn people, but despite clear warnings like the Watson advisement, which is in California at the present time, which informs offenders of the deadly risk of drunk driving. And I believe they also have to sign a document too before they can get driver's license. And the implied consent law is designed to ensure compliance with chemical testing. The system continues to fail. Families like mine are shattered. Like me, I'm shattered, forever grieving the loss of my son. Victims of drunk drivers who were allowed to return the road after multiple offenses. Criminal gets all the rights, and it's so unfair. Because believe me, my son would be alive today if something had been done when he was first stopped. But nothing was. It's a heartbreaking cycle that demands vigorous enforcement and justice for those who can no longer speak for themselves, like my son Kenley. Now, let me talk a little bit more about the Watson advisement. Now, it is a legal warning specific to California, given to DUI offenders, informing them that if they continue to drive under the influence and cause a fatal accident, they can be charged with second-degree murder. And I know this happened in California. It holds repeat DUI offenders accountable by making them aware of deadly risk of impaired driving. But then they find out about plea deals, case overload that can set them free. Now, the implied consent law, which exists throughout the United States, it requires drivers who are lawfully arrested for suspicion of DUI to submit to a chemical testing, breath, blood, or urine. Refusal to comply to these results in penalties, including license suspension and fines, emphasizing cooperation importance in protecting road safety. But wait, Texas will not take driver's license away from anybody, even if they killed somebody. Okay? And they can get away with not taking a breathalyzer test if they're too drunk to take one. Now, laws like the Watson advisement, or excuse me. Yeah, well, like the Watson advisement and the applied consent law are supposed to hold offenders accountable and deter drunk driving, just like the 24/7 law here in Nevada is supposed to do so. Still, repeat offenders continue to slip through the cracks. Man, they know how to get around. They know how to get away with things. And believe me, out of what some parents consider love or loved ones consider love, they bail them out. And there's where the problem is. Still, repeat offenders continue to slip, like I said, through the cracks, even with these laws. The harsh reality is that these laws aren't consistently enforced, and the reasons are complex. And believe me, I am so frustrated with them. My son would be alive today. Now, this is the same thing as what happened with Dennis, the man who killed my son Kenley. He had 2 bonds. Okay? 2 bonds. The first one was $150,000, but wait a minute. They reduced it down to $80,000. So he would only have to pay 8%, I think 10%, which would be $8,000. Which he did get the money through his brother and grandmother. But he was so grateful, he disappeared for 6 months and was caught and given another bond. I would say a reward, since this was a PR bond. Now, a PR or personal reconnaissance bond allows a defendant to be released from jail without paying bail up front. To me, he was given a gift. Instead, they signed an agreement to appear in court and follow the judge's command. What makes anyone think someone who's done what that man did throughout his life trustworthy? But these PR is typically granted in this is what ticks me off, less severe cases where the defendant isn't considered a flight risk. This was Texas. He was Hispanic, although I believe he was born in the United States. Don't you think that might be a flight risk and he's up for a long jail time? If they don't comply, they could face additional charges or arrest. In short, it's a right or secure release based on trust rather than money. Trust. This man took a baseball bat after somebody. He hit his girlfriend or somebody in a bar or someplace where they had to call the police. I mean, he was a real nice guy. Now, this just ticks me off. When someone kills another person due to DI and has prior offenses on their record, it raises serious concerns about why such a person would be granted a PR bond or treated as a lower risk. Why would it? Why would you take the chance? And yes, my son would be alive today if they hadn't. The idea behind a PR bond is trust. How can you trust somebody? He already disappeared for 6 months. Even his grandmother didn't know where he was at. The court assumes, here we go again, you know what assume means, that the defendant will comply with all legal obligations because they don't pose a significant threat to the public safety. He didn't abide by the judge's other rules and regulations, like, hey, not disappearing, reporting in. Why would he do it now? I mean, it's just maddening, it's what it is. All of us that are parents, and I'm an ex-school teacher, I cannot imagine what would happen in my classroom if I applied that common sense. Honestly, classifying this as less serious is a flaw in the legal system where repeat offenders do exploit loopholes or leniency. Honestly, to me, it's an insult. It's an insult. Granting leniency to someone who has already shown dangerous behavior not only endangers the public safety, but also disrespects the victims and their families. Like I said, to me, it's an insult. Who suffer the consequences of repeated system failures. Why do criminals get so many rights? They're criminals. They've done something wrong. They should not get patted on the back and say, well, that's okay. You didn't mean to do it. It wasn't an accident. It was an accident. No, it was a crash. You killed somebody. Now, this imbalance between trust and accountability can lead to, well, in my case, loss of my son. He was given another chance to break the law. In fact, he was given many chances to break the law. He has had problems for years, and I think you may find that out in a lot of the cases. Now, like I said, get back to the PR bond. He disappeared again for 3 months. He was supposed to have a GPS ankle monitor, which would have allowed him to be tracked. But to my knowledge, he never complied. Now, again, the judge can set up all these rules and regulations, but then the case is transferred over to the probation department. If the probation department shoves it in all the other cases that they have, and it gets lost, essentially. And no one follows up. But not once, but twice in my case. I know the excuse was that the parole officer had too many to care for. One of the biggest challenges is the sheer need for more resources. Now, I understand that because I was married to a police officer. Kenley's dad was a police officer. Now, police nationwide are understaffed and underappreciated, let me tell you. And if they breathe, somebody will say or complain about it. One of the biggest challenges is the sheer need for more resources. Now, police nationwide are understaffed. I know that. And probation officers are overwhelmed with caseloads they can't manage. I understand that. But it's still not right. It's still not fair. My son would be alive today if there would be stronger laws to begin with. In other words, tell your family, tell your friends, tell everybody. If somebody in their family gets drunk and ends up at the jail, keep them in there. Don't bail them out. That's tough love. Of course, I never had to do that because Kenley never, ever would drive after drinking a lot. He never had a ticket either. He never had an accident. And I know there's a lot of kids out there, a lot of people out there. I'm another one that's never had anything. Now, without enough officers on the street or enough resources to monitor the offenders on probation, these individuals aren't being held accountable. They lack the enforcement needs that dangerous drivers should be kept off the road and go unnoticed. Again, first there's the problem underfunding. Many police departments and probation officers simply don't have the budgets to hire enough officers to track and monitor repeat offenders. Without the manpower to monitor these individuals, enforcement becomes inconsistent and allowing offenders to slip through the cracks. In cases where police are stretched thin, more urgent crimes will often take priority over monitoring DUI offenders. And as a result, these offenders continue to drive unchecked. Second, the legal system itself is overwhelmed. Like I said, courts are backlogged with cases and there's constant pressure to process them quickly. I've said this over and over and over again. This often results in a plea deals that reduce serious DUI charges to lesser offenses. Like I said, they tried to do that. They tried to get probation to Dennis. When he only killed once. It's maddening. This is especially true involving repeat offenders who, instead of facing real consequences, they can often strike a plea deals that keep them on road. States like Texas, like I said, do not take driver's license away even after they kill someone. And this is what the DA told me. So as my son was being taken away in a body bag, Dennis was released from the hospital to his mother that night. No jail. Why? He was too drunk to take a breathalyzer. Oh yeah, too drunk to take a breathalyzer. A warrant is typically needed to give blood for a BAC test, which takes then approximately 10 months to get results, which it did in this case. Only then was an arrest warrant issued. He was driving 10 months, but still no jail time. He bailed out and disappeared for 6 months. Yes, he still had his driver's license. Finally, there's the issue of overcrowded jails. Many repeat offenders are given lighter sentences because the system doesn't have the space to house them. Instead of facing the full consequences of the actions, they are released back onto the streets, sometimes with a on the wrist. These gaps in enforcement create opportunities for repeat DUI offenders to manipulate the system, and believe me, they know how to do it. They know how to delay court proceedings, exploit legal loopholes, is what I'm trying to say, and strike plea deals to avoid serious consequences. And believe me, there are some shyster DAs, defense attorneys out there that will help them in all this. Even worse, the already a burden system often allows them to get away with it. They turn a blind eye. Why? Too many cases. They have to get them off their desk. That is why you have to be the squeaky wheel and always be involved. It's a terrible reality that people who should be held accountable for their dangerous behavior have learned how to work the system. I don't know the system. They understand that probation officers can't watch them closely, and that courts are more likely to offer leniency to ease the pressure on overcrowded jails. For families, or for me, this is just frustrating and devastating. My child, my Kenley, is no longer here because someone who should have been behind bars was allowed back on the road. It is not just the legal system that enables this reckless behavior. In some cases, loved ones think they're helping by repeatedly bailing offenders out of jail, considering it's an act of love. But this enabling doesn't stop this behavior. It only encourages it. The mentality, they'll learn the lesson the next time, is dangerous and irresponsible. What people fail to see is that this isn't love. Bailing someone out repeatedly only allows them to keep putting lives at risk. And as someone who's lost a child because of this reckless behavior, I can tell you, there is not a next time for me. I paid the price of what leniency. Now, Kenley's life was cut short because of a repeat DUI offender, Dennis Rodriguez Abeyta Jr. was cut short because of a repeat DUI offender, Dennis Rodriguez Abeyta Jr., and was given endless chances to change, but never did. It's beyond painful to know that even after multiple offenses, these individuals still find a way to avoid facing the full consequences of their actions. The laws meant to protect us aren't enough. They aren't adequately enforced, and offenders can easily find a way around them. We need more vigorous enforcement, stricter penalties, and fewer opportunities for leniency regarding repeat offenders. There should be no more slaps on the wrist or looking the other way. The system needs to step up and protect our children. No family should have to go through what I've been through or what we've been through. Losing a loved one because the system failed to act. We need real changes to stop repeat DUI offenders from being given endless chances to continue their reckless behavior. The time for leniency is over. It's time for accountability. If this message resonates with you, if a DUI tragedy has impacted you, or you want to help push for stronger laws and support, please share this video. And stay tuned for more content that addresses many critical situations and issues. Together we can make a difference and keep our roads safer. Thank you.